Thank you very much for joining us here today. Can you guys see the PowerPoint presentation?
Yes, I can.
Wonderful. Thank you again for joining us for today's estate planning for Momentum Families. My name is Rafael Magana, and I'm the plan giving manager at Momentum. Nice to meet each and one of you. We appreciate you taking the time to join us for today's presentation, Estate Planning for Momentum Families, with our guest presenter, Stephen Beltran. We value everyone's time and we'll keep the presentation today to 1 hour. Presentation is being recorded so it can be shared with other families and used as a reference. Mr. Beltran is a plaintiff attorney representing foster children and people with special needs in personal injury and governmental tort litigation, special needs trust, probate, and mental health proceedings. Mr. Beltran also represents private professional fiduciaries and private trustees in court supervised special needs trust and conservatorship accounting. Mr. Beltran also serves as a private mediator, as a volunteer settlement attorney in probate department of Los Angeles County Superior Court, as a court-appointed counsel, and as a guardian ad litem in Los Angeles Superior Court. He is also a member of the Los Angeles County Bar Association Trust and Estate Executive Committee. Mr. Beltran is also the current chairperson of the board of directors of the Exceptional Children's Foundation and a past president of the board of directors at the Frank D. Lanterman Regional Center for Developmental Disabilities. Mr. Beltran received his JD degree from Hastings College of Law in San Francisco, California, and is licensed to practice in the state of California, in the Federal, Central, and Eastern District Court of California, and in the Ninth Circuit Court of Appeals and before the United States Supreme Court. Without further ado, welcome, Mr. Stephen Beltran.
Thank you, Rafael, and thank you, Amy, for having the opportunity to speak with you all. You are obviously here because you have an interest on behalf of your family. And I want you to know, I have a family member who has special needs, and that in a way is the driving force behind what I do. And I want to let you have some kind of information on the overall scope of things. The title that we have here, for lack of a better term, is Nuts and Bolts of Estate Planning for Families with Special Needs. I'm not giving you tax advice. All I'm doing is explaining to you the body of law and the basic picture that exists for people with special needs and why and what issues really you need to be keyed to. All right, that's the first page. Can we go to the first slide, please, Rafael? I broke down our presentation about special needs to go first into areas of the different kinds of disabilities we deal with. You can have a medical or a physical disability and not affect a person's cognitive capacity. It can be something that you break an arm, or you get injured in an automobile accident, or you have a stroke and you're not able to do anything for yourself further. That is a type of disabling condition. It can be physical and it can be medical, it could be mental even, and we'll get into mental illness in a little bit more. But this is one type of disability that is important for us to understand. Next one, please. Developmental disabilities. Now, I understand that many of Momentum's UCP's, former UCP's clientele are regional center clients. I work with regional center clients all the time. Many of my clients are regional center clients. I represent them in cases for injuries they have, either in special ed at a school or in foster care, because a lot of my clients are foster children. So the developmental disability now, if you go back one slide, please, Rafael. The Welfare Code 4512 describes regional center eligibility. If you can show an onset of a severe developmentally disabling condition before age 18. It's mental retardation is an old term. It's an intellectual deficit now is how it's used. Cerebral palsy, autism. And then there's a fifth category of conditions similar to those of other people that are described specifically with a developmental disability. So that is the first area that you have in terms of service agency, and I want you to know about it. You may already know very much about it. Next one, please. Next slide, please. We get a feedback too. If your microphone is on, please mute it so that we don't get feedback. Thank you. There's 21 regional centers in the state of California. They mirror, basically they overlap mental health districts. The most populous is the Southern California area with 7 regional centers, and developmental disabled people have lifelong limitations in their capacity. All right, so those are kind of 2 groupings that we have of disabilities, medical and physical, and then developmental disabilities. Next, please, next slide. Now, there are government benefits that one can qualify for. Certain of them are entitlements. An entitlement program is one where you have paid into the system. You have a right to get money back from it. That's like for people who have paid taxes through their work or as a self-employed person. That's an entitlement program. If you get injured and you've been working, you can qualify for SSDI, which is Disability Entitlement Program eligibility. And that's based on how much you've paid into it. Next program, please. Next slide. Then there is another entitlement program called the SSDAC. Now, when you reach the age of 65 and you have an adult and as a paying person into Social Security, your children are qualified for SSDAC. It's a lifetime combination of program eligibility under this program, SSDAC, and SSI. You can combine the 2 programs, but you can't get the combination of both programs, but a maximum that is determined through the Social Security Administration. Currently, it's around $1,500 or $1,600 a month combined benefit maximum under SSDAC and SSI. You get Medicare insurance as well. And if you're an SSI recipient, you get Medi-Cal. So you get through SSDAC entitlement benefits. If you combine them for an adult disabled child, you get the combination of SSDAC and SSI together with Medicare and Medi-Cal. They call that Medi-Medi. Next slide, please. Now, these 2 programs I've described for you so far are the SSDAC and the Social Security Disability, SSDI. Those are based on entitlement, paying money into the system. The different category is needs-based public benefits. This is SSI and supplemental security income and Medi-Cal. So you get the monthly of up to approximately 900 and something. There's a slide I have next that'll come up on the amount, but you don't have to be working. This is needs-based. You can qualify for these benefits if you are indigent, and that meaning you have no more than $2,000 in cash that is non-exempt, or other assets that are non-exempt. But there are eligibility requirements to qualify. Apart from having a disability and a qualifying disability, you must also be indigent. Then the Medi-Cal is the insurance coverage for it. And that includes also in-home support services, which is a critical element and component of the benefits that our clients receive. Next slide, please. So most people with special needs rely on SSI. An adult child, my daughter, can qualify for SSI based on her own need. She can qualify for SSDAC as well based on my contributions, having reached the age of retirement that I reached. And then she gets Medi-Medi as well as a combination of the SSI and the SSDAC. But people with special needs who can't work get this needs-based eligibility, and it's based on their indigency. Again, they can't have an estate, and we'll talk about what an estate means. You can't have money that they could use themselves, and you have to be disabled. There's no work requirement here for SSI. Next slide, please. So here are the qualification requirements. They got to be 65 or older, legally blind, or meet the definition of a permanent disability. And this would be on an application that you would make, that the person would make through the Social Security Administration. The issue of what is a disability is contested sometimes or from time to time. So there are guideline requirements for it. And if you apply for those benefits and you're denied them, then you can also appeal through an administrative hearing with the Social Security Administration. There are offices in West LA that handle these types of appeals. Now, the financial part of it is, if you have that handicapping condition, that disability, and it can be seen to last more than 6 months or become permanent, and you can't be working because of that, then you don't have more than $2,000 in non-exempt assets, then you're eligible for this needs-based SSI and Medi-Cal benefits. Next slide, please. Now, so the SSI is needs-based. You're going to be looking at income, how much you have, and if you have an inheritance or property that comes to you, like a gift from a family, or you get a settlement in a personal injury action, and it kicks you over that $2,000 limitation, you've got a problem, and you have to do something about that. So you can see here that a single person's eligibility is no more than $2,000 in non-exempt asset for a single person, $3,000 for a married couple. And the resources that they talk about are cash, savings, equity in property, or in real estate value that you have, or a source of income, regular income that comes in. Next slide, please. The current monthly, and I checked this just last week, the current monthly now with the new 5.6% increase, or whatever the 5.9, is $841 per month for a single person. And again, the SSA and the SSI benefits can be combined, but you can't get a combination of the two, but a calculated monthly payment based on the two and on contributions and on the person's need through SSI. I should point out, when a person applies for SSI, a lot of times children are living with their parents and the child reaches 18. That child is then eligible to apply for SSI, him or herself. And parents sometimes say, oh, well, I can't charge my child rent. That's my child. I love that child. I'm going to feed it. I've done it all of life through its minority. But when you apply for SSI, you've got to show that that person has a financial need, and not only the disability, but a financial need. And the need is based on what is the proportionate share of rent, what's the cost of food, clothing, and personal and incidental money. So that $841 maximum now is based on the showing by a petitioner or an applicant for those benefits that they have a share of cost of rent, and it should be maximized. You can look at Zoom or wherever on the internet and find what the rental value is for your home and get an idea what that would be. But then you've got to charge for food and you've got to charge for clothes, because those are expenses that are going to come out. And if you don't do that, Social Security sees that income or the contribution by the parent as income, and it reduces the need, the financial need on the application for SSI. So you've got to be tough, and you've got to show that your child has a right to live independently and has a right to these benefits independently of the parent. That's how you maximize it. Next slide, please. Okay, one of the other benefits or entitlements, if you will, that a person with special needs has is the right to a free, appropriate public education through their 22nd birthday. And the reason I put this on is because we're going to be talking about capacity, a person's ability to make decisions for themselves. As a minor, person is incompetent or lacks capacity just because they're under age 18, unless they're emancipated. Once they turn 18, there's a presumption that they're competent. So the problem that comes up is when you have special education services Go to the next slide, please. These services are described in an IEP. And these IEP meetings or individual education plans for a coming year are put together and revised reviewed every 2 years, or excuse me, every year, with a review, a large review every 3 years. Now, this is important because who's making the decision? The parent or the student? There's the team. You can see the list of people that are listed there. So who is it that's going to be making that decision? Next slide, please. School districts, and correctly, when a person, despite having a student in their district that may be substantially unable to make decisions for themselves through their minority, when that person reaches age 18, they are presumptively competent because no court has ruled that they are unable to make decisions for themselves. So the school district's going to tell you, well, reached 18, okay, we're going to rely on the student's signature for the IEP. What's good, what's bad? What are the goals and objectives that you've been including there? Which ones are contested? Who should pay for it? Is a public school appropriate? All of those are issues that come in on an IEP and special education through age 18. So it raises the issue, if you can see the second bullet there, at age 18, all parents should consider seeking appointment as their child's general or limited conservator to properly advocate for their child. All right, next slide, please. High functioning students, when you are dealing with capacity issues, high functioning students can make decisions for themselves. When we get to the area of conservatorships, we'll go into these powers. These are what are known as powers under a limited conservatorship for people with developmentally disabled limitations. So the key powers I think of are the ones about where a person lives, access to confidential records. This is, imagine what import these are. The right to contract. You pay for services, you do it by a contract. The power to give or withhold medical consent. And this is interesting too, because it can be life terminating decisions that may be involved at some point. So it's carefully crafted to articulate these 5 powers. And then the last one, obviously, the decision regarding education powers. So these are only part of the 7 powers, as well as the right to vote, that a person has, a person with developmental disabilities, they come into at the time they reach majority, age 18. Next slide, please. Okay, regional centers, again, this is an entitlement. It's by the welfare code. The welfare code says people with developmental disabilities, as described, are entitled to certain services, and they get an IPP, a Regional Center Individual Program Plan, or IFSP, they call it different terms. I'm an old guy, so I use the old term, IPP. That's one I learned to begin with. It's still the same functionally for me. But again, who puts that plan together? Next slide, please. It's typically the regional center and their care provider, I mean, their service coordinators, and the parents then will come in, and I'm sure many of you here today have had the experience where you don't even know what to ask for. And the regional center is not going to offer you a carte blanche on what is available, but they have a duty to tailor and create services that are appropriate to minimize the impact of the disabling condition and to allow the child to live, or your adult child now, to live as independently as possible. So that goes back to those civil rights that a person has. Right to vote is another one of them that you throw in there. Where's the person going to live? What records do they have? Right to contract, power to give medical consent. All of those are incorporated not just in an EP, but similarly in an IPP for regional center services. Okay, next slide, please. Okay, so now we're in the issue in the area of authority to act on behalf of a person with a limitation. A person, this is again, capacity. Does a person have the ability to make decisions for themselves? You're under age 18, you presumptively have no ability to make those decisions. A parent, a biological or adoptive parent, has legal authority to make decisions for their minor child. Next slide, please. And a guardian would be appointed if a parent were not around. It could be aunt or uncle or even an older sibling who petitioned to become the guardian of their minor sibling for that person's person, the person, medical, food, and residence. That's what is entailed in a person, guardianship of the person, and the estate. And again, the estate is money. So we're talking, keep in mind, if you're talking about a conservatorship or a guardianship, and your person, your client, your child has an estate, there's a red flag raising. Okay, what's going to happen if they've got that estate? How will it impact the person's eligibility for financial government benefits, which are needs-based? Okay, so you want to avoid an estate for a person with special needs who may be required to be reliant on government benefits like Medi-Cal and SSI, but that's not going to impact them on the component that goes to entitled benefits under Social Security for SSDAC and Medicare for the child of a retired person who is paid into the system that we discussed earlier. Next slide, please. So now we're talking about guardianships for minors. The next issue of kind of protective or having authority over a third person is what's called a general conservatorship. Any one of us can have an accident or suffer dementia or some other kind of limitation and have a conservatorship appointed for us. If we are not developmentally disabled, then a general conservatorship is the usual tool that you may have heard of. The Britney Spears thing was a general conservatorship of her person and of her estate. She's not developmentally disabled, but I use her only as an example of how it applies for different people. There's different categories of conservatorships. But regardless of any mental or developmental limitation, adults have specific legal and civil rights that can't be modified without a court order. So when a conservatorship is established, the court has to make particular findings. And under a general conservatorship, whether for the person or the estate, it has to be articulated on what the powers are. So the conservator is given, and so is the guardian in an appropriate case. They get letters and orders of either guardianship or conservatorship of either the estate and or the person on what they're authorized to do. Now, important distinction here is we look back, I talked to when a person reaches age 18, they presumptively have capacity because no court has yet made an order modifying their legal rights. Okay, so the third bullet you see here is medical incapacity is not the same thing as legal incompetency. That has to be found to exist by a court order limiting that person's rights to their person and or their estate. Next slide, please. And here's the thing of the conservatorship of the person. And this goes to what is necessary to protect for food, clothing, and shelter. And I think that's enough on this one because it's sort of repetitive. Go to the next slide, please. Conservatorship of the estate. Now, this is going to be the area that everything we talk about here today really comes to focus on. An estate is a person's real and personal assets, bank accounts, checking accounts, stocks, bonds, gifts to minors acts. Aunt Louise is leaving $50,000 to your child when that child was born. and now your child has reached 18 and that she has a right to that money. That's a typical thing that happens on how people come into money that have special needs. But again, the estate itself can disqualify the person from government benefits because they are over the $2,000 threshold of non-exempt cash or other assets. You've got to find a way to manage that estate in a way that allows for continued eligibility for SSI and Medi-Cal and all other government benefits. Now, an estate too, third button on there, if you have an estate and it's under court supervision, there has to be periodic court accountings, like every 2 years, and there are recurring attorney's fees, trustees' fees, or guardian or conservator's fees, because they're the ones that are making the call, and they can't serve without an attorney. So there's also attorney's fees, and there will be a bond required for how much money is in that estate. And every 2 years, that bond is adjusted up or down depending on how much is left in the estate. Next slide, please. Okay, so this is an important section because there is a way, if the benefits are comprised only of, if the estate is comprised only of 2628 and Medi-Cal, and there's less than $15,000, you don't have to have an estate, and the court can waive accountings and bond. If it's more than $15,000, then you're going to face the issue of how do you shelter that money? And if you're going to put it into a proper type of special needs trust, it has to be, if it's court supervised, it has to be subject to a payback to Medi-Cal. Now, payback is it's a red flag too. In my mind, what happens, and it's included in every trust, every special needs trust that's court supervised and requires accountings. Payback is at the termination of the trust, whatever is left over after administrative costs of fees and costs to the attorneys doing and the trustee or guardian or conservator doing the accounting to terminate the estate. The Department of Healthcare Services and all taxpayers who have advanced payment of the benefits for Medi-Cal have a right to be reimbursed. And that right to reimbursement includes every penny that was paid from date of birth until the termination of the trust. So it can eat up whatever is left over, and typically does. I have a case right now where the payback claim is $4 million and some dollars because it was a substantially disabled person who passed away, and now that's the payback that we're looking at. All right, we'll talk more about paybacks in a little while. Limited conservatorship. Now, this is for regional center clients, people with developmental disabilities. Limited conservatorships are limited to the extent that they are only necessary to promote the least restrictive impact on the person's rights. And they vary. Person with autism, epilepsy, palsy, and intellectual deficits have different ranges of functional capacity. So the power for each client in a regional center limited conservatorship, I should say, depends on that person's ability to do things for themselves. And again, least restrictive so that it's to promote their maximum civil rights. Next slide, please. Now, here are the powers. If you have a limited conservatorship for an adult person with developmentally disabling conditions, they include this menu, if you will, of 7 powers, together with the right to vote, which is not included here. But we've already talked about the ones of domicile, access to record, and a new one now, number 3, is the right to marry. And number 6 is the right to decide on social and sexual contacts and relationships. These 2 areas are big areas of contest in the probate court because children who are now adults want a life and they want to do what everybody else is able to do. They can make choices for themselves. They may agree to mom or dad being the conservator, but they may object to any one or all of these powers that we're talking about. I get appointed by the court on petitions for family members to become the conservator of their child and on a regional center developmentally disabled type of case. And typically this is the battlefield. Regional centers now, they know how your son or daughter have been able to do because and function because they provide services under an IPP. So they are required to make a report to the court on what they believe to be the ability, first on whether the petitioning person should be appointed and whether or not which of the powers should be granted. Hold it back there for a second, will you please, Raphael? Go back there once. This has been an area of interesting contest. Regional centers are required to make a report to the court on which of the powers should be granted and whether the person petitioning should be appointed. Parents who are advocates for their children oftentimes have a running battle with the regional center about the type of services that they are seeking. So I've seen it in a couple of occasions where the regional center files its support, but objects to the parent being appointed because they have been overly advocating, in the regional center's opinion, for the person under the conservatorship. So that happens from time to time. Next slide. Okay, now we're talking about estate planning. Again, there are no tax counseling or advice that I'm giving you here. It's merely an overview for you of what to do for a person who is receiving government benefits on the basis of need. Okay, they've got to be impoverished or under the eligibility requirements for SSI. And a typical kind of plan is a revocable for parents. This is, I'm saying, it could be a revocable living trust. So the parents make a trust for themselves. They carve out in that a special needs trust for their child who has special needs. And they may give, they say they have two children. The one with special needs is going to be under a special needs trust, under the parent's trust. There's no payback for that. If the other sibling gets the other share free of trust, however the family puts it, decides. The second part of an estate plan is a pour over will, so that anything that is not in the living trust at the time it's drafted and at the time of the settler, they're called, the persons who made the trust, the death of the last of them, the pour over will goes into the living trust, it captures whatever was not named in the trust. Another component is the durable power of healthcare for medical care. That's for decisions for the people making the trust. Those are the settlers. So mom and dad make their living trust. They have it's revocable, so they can change it during their lifetimes. On the death of the first of them, the part that belonged to the first to pass is no longer revocable, but the remaining survivors' share is revocable. And then you have these powers of attorney, but could be my older child is going to be in charge of making healthcare decisions for me. It's going to make healthcare decisions and financial decisions for me being the settler. So that's the typical components of an estate plan. Next slide, please. Now, sometimes parents decide, or at the time of their passing, have no property or no thought that they need to have any will. If a person dies without a will, that's called intestate succession. It has to be probated. There's a cost for probate. It's expensive. And if the money that comes by an intestate succession goes to a person with special needs, then the court can set up a special needs trust on appropriate petition. But then you face the issue, if it's a court supervised trust, you're going to have Medi-Cal and SSI payback at termination, and you're going to have court supervision and recurring accountings. So you can see where the money that goes without a will and goes to a person who is relying on needs-based benefits, there's going to be a cost there. Who's going to do that? It's going to necessitate a conservatorship. It's going to necessitate If there was no estate previously and it was a conservatorship only of the person, now you've got an estate. And here comes the estate that needs to be dealt with. Next slide, please. So then parents a lot of times will make trusts, will make deeds, and they say, I leave my property to my 2 children in equal shares. Or I leave it in the name of one child, supposedly for the benefit of the other. That creates a problem because the title is in the name of that one person. There's no obligation to give to the other, the other being the person with special needs. So again, this creates an estate, and it's subject to a petition to set up a trust. Third bullet, you're going to have to go to court, and you're going to have to do a special needs trust that will be subject to payback. If the family had done a living trust or made a will with the trust and created a special needs trust there's no payback. So here we go. That's what we're talking about now. Depending on the size of the estate and the need for tax planning, the means of leaving assets to a person with special needs is by use of a will or a living trust. And properly drawn, it can include a special needs trust to shelter the assets for your person who's receiving those benefits of government, SSI, and Medi-Cal with no payback. All right, what's a special needs trust? It's a tool to hold, administer, and distribute assets for another person to enhance the quality of their life and keep eligibility for ongoing receipt of government benefits. Next slide, please. The special needs trust requires that the trustee is the only one who has authority to make decision over when and if and how much money is paid out of the trust. It's up to that trustee. The beneficiary cannot have control over the property. Otherwise, it's a sham. It's a straw kind of tool, and SSI will invade it and challenge it and and cancel government benefits. Another thing you should know is that if there is a challenge to SSI and Medi-Cal benefits, the challenge can come from the Social Security Administration and be for and what they call an overcharge and a demand to pay back until the money has been repaid, or to terminate the benefits. So it's important to keep eligibility. The third bullet is that the beneficiary, hold it there, please, Raphael. Go back one. Thank you. The beneficiary can't be their own trustee. And the trust can only supplement, not take the place of, but supplement government benefits for things that are not covered. Special things, a trip for an attendant and the person with special needs, including food, lodging, and transportation. That's a reasonable supplemental use or disbursement. Buying a car, because a car is an exempt asset. Buying a house could be appropriately used. But when you're talking about larger amounts of money, but the trust can only supplement what's not paid for by public benefits. And the trust assets are exempt from calculation for a special needs trust. Assets are exempt from calculation for government benefits. Next one, please. Now, this law in 1993 is the law that carves out the ability to exempt monies that or funds that are received by people with special needs, but it requires a payback, and it requires a payback through a tool called a special needs trust. So this is the law that authorizes establishment of a special needs trust and requires the payback. Next chart, please. So this is the trust requirements and all the components of what's required. They can't have more than, the person has to qualify for indigency, non-exempt assets. These are technical pleading requirements for the establishment of a special needs trust. Next one, please. And these are, you should speak about these questions you have about them with lawyers that you're going to be consulting with for purposes of drawing up your will with an appropriate special needs trust. Okay, so where does that money come from? These non-exempt funds that disqualify or threaten eligibility for SSI and Medi-Cal non-exempt or needs-based assets. The UGMA, that's the Uniform Gifts to Minors Act, where payments go, Aunt Tilly leaves $50,000 to your child during their minority, or inheritances, Aunt Louise or grandma leaves $100,000 to your child on her passing. Wills, or that parents pass away without a will, property goes to their children, goes to intestate, it goes to the blood, and it goes in equal shares. Personal injury awards. Now, this is the main area that I get settlements for my clients and shelter the settlement through a special needs trust. And that's how we do it. The court, you have to get the court's approval to establish the trust as a first party. That's where we see that on the bottom, that second bullet. Next slide, please. So there's different types of special needs trust. There's the first party by parent, grandparent, legal guardian, or the court. That's the court where you put that settlement in. Assets, under the person's underage when the trust is established, is currently disabled, and on the death is the trust includes payback. And again, payback on these court supervised and court established special needs trusts. It goes from date of first payment by Medi-Cal until termination of the trust. Next slide, please. A third party special needs trust. This is mom and dad doing their living trust and putting it in a share that they're going to do for their child with special needs. They're going to put it into a trust within their trust. It's a subtrust of the parent's living trust. There's no payback here because it's your property and part of your estate plan. It's your money that you're doing as you choose to do. Next slide, please. Now, people, how much are we talking about as the corpus or the money that's going to be sheltered under a special needs trust? Some trusts are small. It doesn't sound logical, but even up to $500,000 could be seen as a small trust. A lot of trusts and a lot of personal injury cases, even against school districts or the county of LA, can be for $100,000. Well, that is not a lot of money because it's supposed to last for the lifetime of the beneficiary to supplement the needs that they have that are not covered by government benefits to enhance quality of life. So you can see that that $100,000 can go pretty fast. Now, a pooled trust is valuable because it allows for a nonprofit to put together different accounts for different people and manage them by pooling them with one advisor and minimizing the administrative costs for the investment of that money. These are very valuable and they're appropriate because there are separate accounts that come up for you for the money. The accounting is done all by the pooled trustee, pooled master trust trustee. And next slide, I want to get to that. We're almost there. I see you there. Okay, and again, there's a payback, and it is in a separate account for each of the beneficiaries. Next one, please. Okay, so here we're getting to what we've said before. People with special needs, parents should be planning a special needs trust for their child as part of their own estate plan. It should be appropriately drafted, and if you're doing it as part of your own estate plan, there's no payback. Next slide, please. Next slide, please. Big picture. I'm going to pitch to you an agency that does pooled special needs trusts. It is the Jewish LA Special Needs Trust, Pooled Special Needs Trust. They're available online. I have on the last slide, but I want to give you this. The big picture for a person with special needs. You need to have a personal checking account to receive the SSI payments and any working earnings. You pay rent, et cetera, from that. That's your food, clothing, shelter. That's where the 876 or whatever it is monthly goes. The second component is what's called a CalAble account. You can put money, if you have in a checking account and it's going over $2,000, you can deposit it into a CalAble account. It earns money, it's invested, and it's not calculated for SSI eligibility. And it pays for additional benefits like assistive technology support and supplemental expenses, even rent, without reducing SSI and Medi-Cal. CalAble.org, you can get it online. And then the third party special needs trust we talked about, that's the one with that's the payback if all else fails. But now here is the contact information for the Jewish Los Angeles Special Needs Trust. Michelle Wolf is the lady who runs it, the administrator. She's a wonderful person to talk to. You can look online for their website, and all their application for a pool trust are available online as well. Hopefully we have time for a couple of questions if anybody has. That's the end of my presentation, but I really urge you all to take the time, consult with an attorney to do a proper living trust, to include a special needs trust with no payback. You may not be able to avoid a payback requirement if money comes in from some other source. Thank you.
Great. Thank you very much for that. We want to allow some time for questions. If you can please type them in the chat box. And Stephen, thank you very much for just going over estate planning and how to minimize the available public, maximize the public benefits, the types of special needs trust, and what a special need trust is. So thank you very much for that.
My pleasure. Thanks for inviting me.
While we wait for some questions, here's a question my wife had. How would you get started to make a special needs trust? How can people get started?
Look, if you don't, ask around, find a lawyer that does estate planning. Preferably it'd be somebody who does, who is certified as a trust and estate specialist by the state bar. Okay, there are a lot of them. You can contact the LA County Bar Referral Service for a certified estate planner. It's called Smart Law. They have a referral service there for attorneys for these types of cases. Or ask around, but feel out who it is and be comfortable with the person you're working for.
Great. We have a question from Sharon. What is SSDAC and how does it work?
SSDAC was the entitlement portion of government benefit of monies that come for people who have worked and become disabled, and they have a right to receive money for the during the time that they're not able to be employed. It's an entitlement program. It's available on the retirement or death of an insured parent to a child whose disability started before age 18. You can look for that SSDAC online with ssa.gov.
Great, thank you for that answer, Stephen. Here's another question. How can you do a special needs trust for a sibling? And can you set up a CalAble account for a loved one living in California?
Wait, that's,
if you don't live in California.
What are you asking for? First one I heard was a special needs trust for a sibling. Okay, there is a type of trust that can be put together called a standalone, where I could make right now a living trust for my child, a standalone trust for my child, and invite the world to make contributions to it. That's a standalone. And that's what you're talking about on a sibling making a trust for their other sibling. There was a question also about CalAble. CalAble, you apply for them for that program through calable.org, and all the information and requirements of that program are available through them. Michelle Wolf hosted a CalAble program and has a PowerPoint that would be of interest to you too. But she has that, it's www.calable.org. That's the website for them.
Yeah, and Stephen, thank you so much. We are going to have all of your resources on our website, so they have one-stop shopping to connect and don't have to remember all of those, but thank you.
Good, that's what I need.
Here's a question for you, Stephen. Can a special needs trust have more than one trustee at a time?
Yes, parents can be. Often I've had several cases where parents for their child who was injured in school are co-trustees. If you have a conflict or any kind of basis for a conflict, you don't want a co-trustee. A co-trustee as a parent is one thing, but private professional fiduciaries also serve as trustees. They're licensed and bonded by the state, but they do not, for insurance purposes, serve as a co-trustee with other people.
Great. Are there any further questions? Here's another question that came in. Can a trust pay for a beneficiary's special diet?
Yes, I would say so, because I'm a trustee for a young woman since she was 6, and she was injured in a car accident. No, excuse me, she was injured at birth. So she has a lot of limitations, including cerebral palsy, but she's pretty quick and she has limits on her speech. When her special days come in terms of birthdays or vacation time or trips that she loves to go to Disneyland, those all enhance the quality of her life. They're not covered by government benefits. So the issue to me, the threshold question is what you are proposing to pay for out of the special needs trust covered by government benefits? Even if it is it too long a time to wait for it to come? Or is there enough money, or is it an appropriate benefit like a wheelchair that could be purchased by the trust itself? You can do those things. So long as you go through that mental checklist, is there a government benefit that covers this? If not, or if it's not sufficient, does it enhance quality of life? That's how I handle those kinds of distributions.
Wonderful. All excellent questions. And Stephen, thank you very much for your time in answering the questions. I want to, as Amy had mentioned before, we have some plan giving additional tools and resources that you're able to walk through by visiting momentum.giftlegacy.com. We have some free estate planning guides, plan giving calculators that can go a little bit further into some other giving vehicles such as gift annuities, annuity trust, deferred gift annuities, and more, and other subject matters that I think might be interested. If you have any further questions that may arise after this presentation, please contact me. My name is Rafael Magana. I'm the plan giving manager, and you can reach me at 818-456-6785 or at my email at rmagana@momentumforall.org, or you can contact also Amy Simons, our Chief Operating Officers at Simmons at momentumforall.org, and you can reach her on our cell at 818-515-1264. Wonderful. Well, on behalf of Momentum and all of us, thank you so much for attending our estate planning for Momentum families today. And again, please visit momentum.giftlegacy.com for further information. Thank you, everybody, for attending our presentation today. Thank you, Stephen, Sharon,
Thank you.
Tamara. Thank you very much, everybody, for attending.
Thank you.
Bye, everybody.
Bye-bye.